Campbell.
Alexander on behalf of the people.
Ron Brown appearing on behalf of Mr. Campbell, Your Honor.
It's Dejan Campbell. Sorry, Your Honor.
Dejan.
Your Honor, may we set this for final settlement?
Jury final settlement conference be April 10th, 2026, 9 a.m. Jury selection, if necessary, will be April 13th, 2026, 8:30. Both of those proceedings are in person. We'll continue.
It's already set.
Okay. You guys know?
No, I was saying I was trying to get a later time just because I had no contact from my own apartment. I haven't been home in like 4 months.
You're trying to get a what time?
A later time. But if it's not possible, then
A later time like what?
like, you know how it's 1 p.m. today? Like, since I can't go home, I've been having to travel from Detroit out here because I have no contact at the address.
Oh, so you wanted for a final settlement conference and jury selection?
Yeah, I want.
No, they're always in the morning.
Okay, that's fine. I'll make it happen.
All right.
Okay. Hey, we don't play with you.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Now here's what's unfolding. We're watching a packed docket where multiple defendants stand before the court, each facing serious procedural milestones, final settlement conferences, jury selections, bond conditions, restitution disputes. What may sound routine on paper is actually a high-stakes balancing act. Timing requests, travel restrictions, bond compliance, payment plans. Every small detail matters. And as we move forward, pay attention to how the judge maintains control, injects humor, but never loses sight of authority. The tone may feel light at moments, but the consequences? Very real.
Who?
Everyone.
I'm such a nice guy. I don't.
No, you are. You let me go.
I did. I let you go home. I can show you how mean I can be.
No.
Mr. Allen?
No, you
No, what?
All right.
Oh, thank you for that backhanded compliment, I guess. I don't know. 10th and 13th. Court calls the case People versus Eric Champion. Take your hand off before you get it. See, that's how you get in trouble.
Hey, don't go away.
All right.
Jeremy Glick appearing with and on behalf of Mr. Champion, who's standing to my right. Can you state your name and take your hands out of your pockets?
Yes, Eric Champion.
Yeah. All right. What are we doing?
Could we approach briefly, Your Honor?
Oh, no. Every time Glick wants to approach, something goes like sideways. Come on. Yes. It's,
I really just want to ask how your day is going.
oh, is that what it is? Should reflect we've had a friends conference in this case. I'll set jury final settlement conference on this matter for April 10th, 2026 at 9. Jury selection, if necessary, will be April 13th, 2026 at 8:30. Both of those proceedings are in person.
Thank you very much, Your
All
Honor.
right. Thank you.
Yeah.
Thank you, sir.
Have a good day.
Court calls the case, People versus Christopher Seeley.
Alexander on behalf of the people.
Your Honor, David Rudoy on behalf of Christopher Seelig, who is present via Zoom. For the record, we consent to this hearing being conducted
brought all
via
those people
Zoom and
with
thank
him?
the court for allowing it.
Hi. Well, I cleared out half the courtroom. All right. Okay, what are we doing on this case?
Your Honor, at the appropriate time, I'd like to make a request as to bond, and we would like to set this for a final settlement conference.
Jury final settlement conference, April 10th, 2026, 9 a.m. Jury selection if necessary, April 13th, 2026 at 8:30. Both of those proceedings are in person. As to bond.
As to bond, Your Honor, I would note that Mr. Seelig has been on bond for approximately 3 months without a single violation. He is on a tether currently. Part of his bond conditions are not to enter Washtenaw County. His grandson is a patient at U of M hospital and it's a newborn, and he has had to go there a few times. And Mr. Seelig wishes to be able to enter Washtenaw County if his grandson is sick, to be able to attend the hospital. It's happened a couple of times and he's been unable to attend. And secondly, Your Honor, he is requesting the ability to go on a trip to Orlando, Florida from February 27th to March 8th. And I was hoping Your Honor would allow for that. That would just be for purposes of a vacation.
You going to see that mouse? Sir, are you going to go see that
Oh, yeah.
mouse?
Yes.
No, Universal
Oh, good.
Studios.
Because I don't like him. So as long as he's not going there, we're good. Go ahead. What?
Thank you very much, Your Honor.
Hang
Those
on
are
a
the two
second.
requests.
Let me ask for the people's response.
Your Honor, as to the, to both, I will leave in the court's discretion.
Okay. Sir, normally with your grandchild, do you get notification of that they're at the hospital or something along those lines?
I do. My daughter currently doesn't drive, so she's always having to find another way to the hospital. It's been a few late night incidents where I just needed to, go take her, and I haven't been able to take her and my grandson to the hospital. They've Ubered before even, so I mean, it's kind of a messy situation that I have to say no because I can't enter Washtenaw County.
Is and all of the child's care, is that at U of M?
It is at U of M, Mott's Hospital.
Got it. Okay. Indicate is as an exception to his tether that the defendant may travel to Washington County to go to Mott's Children's Hospital. Counsel, I'll need an order to that effect. And then I'll also indicate defendant may travel to Orlando, Florida. Are the 27th, are those including your travel dates, the 27th and the 8th?
Correct.
All right. He may travel to Orlando, Florida, February 27th, 2026 through March 8th, 2026, as long as he's not going to see the mouse.
Thank you so much. Your Honor.
Don't
I'll
put that in the order. I guess I can't do that. Don't put that in.
Okay. Thank you so much. Your
I'll
Honor.
let him go on his word.
Great
Thank
day.
you, folks.
Thank you.
Court calls the case, People versus Jeremy Rice.
And then on behalf.
Now this is where things get interesting. The defense isn't just asking for routine scheduling. They're asking for two significant bond modifications: permission to enter a restricted county for a hospitalized newborn grandchild, and out-of-state travel to Florida. That's not minor. When someone is on tether with geographic restrictions, courts weigh risk, compliance history, and necessity. Notice the strategy here. 3 months of zero violations is emphasized. That's credibility building. And the judge's questions? They're not random. They're testing reliability and structure. So here's the question for you. Should someone on bond be allowed a vacation, even with clean compliance? Or is that a privilege that pushes the limits?
I'm appearing on behalf of Mr. Rice, Your Honor.
Your name, sir?
Jeremy Rice.
Final settlement conference, please.
Jury final settlement conference. April 10th, 2026, 9 a.m. Jury selection, if necessary, April 13th, 2026 at 8:30. Both of those proceedings are in person. Bond will continue.
Thank you.
Thank you.
Thank you.
Court calls the case People versus Cortez Triblet.
And then on behalf of the people.
Ron Brown appearing on behalf of Cortez Triblet.
Your name?
Please set a final settlement in April.
Jury final settlement conference. Seeing a pattern. April 10th, 2026, 9 a.m. Jury selection, if necessary, April 13th, 2026, 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Anthony Williams.
And then on behalf of the people.
I'm appearing on behalf of Mr. Williams, Your Honor. State your name. Williams. Your Honor, we've gone over the pre-sentence investigation report with him. We don't have any deletions, corrections, or additions at this time. I would ask the court for a short adjournment. I just received the request for restitution and documentation for the 2,200 in restitution, and I'd like to share it with him.
What do you mean you just received it?
I asked Ms. Pilar for it, and she was kind enough to provide me with it, the breakdown. But I didn't share it with him at the time I went over the recommendation.
Sure, I had emailed it prior, but I don't think that he had that hard copy documentation. I gave it to him.
All right, well, let me do this. Let me pass the matter. So, and if it's a problem, then I look at it and those things.
So you can have a seat and we'll talk about this if you want to.
All right, so you can look through it. Thank you, sir. Court calls the case People versus Caitlin Morgan.
And then on behalf of the people.
Ron Brown appearing on behalf of Caitlin Morgan.
Chris Blair on behalf of probation. Was Ms. Morgan present? I did not waive her.
She is not.
Is she on Zoom?
She is not.
Your Honor, Ms. Morgan was aware that she did have a court hearing today. I do know, she is reporting. She's still in the midst of trying to get her disability straightened around. I do know when I spoke with her as recent as last week, that she was having family, I think it was her grandmother that was in the hospital. So I'm not sure if that is why she's not here.
Why don't I do this? Let me adjourn this to March 2nd.
Okay, thank you, Your Honor.
Since she's reporting. Adjourn this to March 2nd, 2026, 1 p.m.
Thank you.
Court calls the cases versus Roman Williams.
And then on behalf of the people.
Ron Brown appearing on behalf of Mr. Williams in 1243. He has other counsel in the other matter.
Teresa Claire on behalf of Mr. Williams, please.
Roman Williams. Thank you.
Teresa Claire on behalf of probation. Your Honor, Mr. Williams is for review hearing. Mr. Williams has completed the program component, actually in both cases. However, he has not complied with the court's order with the payment plan. The last time Mr. Williams was before this court, I believe in November, the court had indicated to him to pay $275 and then 2 weeks later pay $275 and then set up a payment plan with him of $50 per week. And probation has always been concentrating on the case ending in 1243, given that there is a large balance of restitution. I've not done anything with any of the monies owed on the other case because I've been wanting him to concentrate on me. I know that Mr. Williams, when I asked about his failure to pay, that my problem with Mr. Williams is that he does not respond to me very kindly. So I don't like that. I'd like to know at least what's going on. And also we want communication so the court is aware Mr. Williams was questioning why he had to pay that. And where
What we've seen today is a snapshot of how structured and disciplined courtroom procedure truly is. From strict scheduling rules to bond exceptions, restitution breakdowns, probation compliance, and financial accountability, the court isn't just reacting emotionally. It's applying consistent standards. Some defendants received flexibility because they demonstrated responsibility. Others were reminded that payment plans and communication are not optional. The judge balanced firmness with fairness, even humor, but never compromised authority. And that's the takeaway. In court, preparation, compliance, and credibility shape outcomes more than excuses ever will. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.